that the live streaming at YouTube has started.
Sorry. I'm
just waiting for that.
I'm really sorry for the technical. So we are
that's
live
fine.
now.
I actually thought we were all frozen, so I thought might as well may ask.
Yeah, no, we are live now.
We are live now. Good evening, everyone. I am Khushi Bhardwaj, and I, on behalf of the organizing committee, welcome you all to the final round of the first NLUO PHFI Public Health Law National Moot Court Competition. After 3 days of intense grilling and rigorous rounds, the teams from Nalsar and Government Law College Mumbai have made it to the finals. For our esteemed judges bench, we have with us Mr. Anand Grover, who is a senior advocate at the Supreme Court of India. Then we have with us Mr. Murli Neelakantan, who is a principal lawyer at Amicus. We also have the pleasure to have Dr. Gagandeep Kang, who is a professor at CMC Vellore. We have with us all the way from United States, Mr. Warren Burke, who is a public health consultant and a senior attorney at the United States House of Representatives. Finally, we have with us Mr. Sameer Shah, who is a partner at Khaitan & Co. I thank you all for gracing the panels with your presence. With the permission of the judges, we may begin the rounds.
May I have permission to address the bench collectively as your lordships?
Yeah.
Much obliged, your lordships. Your lordships, prior to my time starting, if I could just know whether the bench has a preference for us screen sharing the various judgments that we may be referring to, or whether there is no such preference.
There's no need. We know the judgments, unless you can think of something that you think we may not have seen before. But if we want to, we'll ask you.
All right, much obliged, your lordships. So, your lordships, whichever cases we are heavily relying upon, we will attempt the screen share those at least. I'll be starting in 3, 2, 1. May it please this honorable court, I am counsel S1 of team 249, appearing on behalf of the petitioner in the case of Freedom for All versus the Union of Diana and the state of Haryana. If your lordships are well versed with the facts of this particular case, may I proceed to my first contention?
Yeah.
Much obliged, your lordship. Prior to starting off, I would like to provide a brief roadmap of my contentions here today. I will be dealing with 2 major contentions. Firstly, I will be showing that this petition, which has been filed by the NGO Freedom for All in this particular case, is maintainable in nature. And secondly, I will be addressing the validity of the Epidemic Amendment Act with respect to Part 3 of the Constitution of the Union of Diana. Furthermore, my co-counsel here today, your lordships, my co-counsel here today will be addressing the constitutional validity of the regulation issued by the state of Haryana, and along with that, also showing how the same is ultra-virus to the Epidemic Act. If there are no questions in relation to these preliminary statements, may I move on to my first submission, your lordships? Much obliged, your lordships. My first submission here today before the court is with respect to the maintainability of this petition that has been filed under Article 32 of the Constitution of the Union of Diana by way of public interest litigation. Your lordships, Article 32, through a settled law, provides a constitutional remedy against any violation of fundamental rights, and the aggrieved party has been given the opportunity to approach the court for the same if he believes that infringement into his rights has been done to an unfair extent. Additionally, your lordships, the rule of locus standi, which is the right to file a particular action, has been enlarged through the famous case and landmark judgment of SP Gupta versus Union of India, wherein public spirited organizations as well as social action groups, such as non-governmental organizations, have been extended the right to file petitions on the prerequisite that they do so with a bona fide intent and for sufficient public interest. In the present case, your lordships, an NGO or non-governmental organization known as Freedom for All has filed this particular petition and has not done so for any private or political gain, but with completely clean hands, thus meeting the requisites and requirements of this particular court to file a public interest litigation.
Sorry, let me just stop you there. Was SP Gupta a public interest litigation?
So, your lordship, if I could just have a second to clarify that before I answer your question. Much obliged, your lordships. So, Your Lordships, I do believe SP Gupta was a public interest litigation. And in
How?
that particular,
What was the public
So-
interest there, and who was SP Gupta?
so Your Lordship, in that particular case, the government had actually requested non-disclosure of certain documents with reference to correspondence that was occurring between the Law Minister, the Chief Justice of Delhi, as well as the Chief Justice of India concerning the appointment of judges to various posts. In that particular case, it was held that it was not against public interest to issue those particular and disclose those particular documents. And as such, the PIL was held as one that was maintainable in nature. If that satisfies Your Lordship's question.
Yeah.
Much obliged, Your Lordship. So, Your Lordship, along with that, in the present case, I would like to present a caveat with reference to the judgment of Municipal Corporation of Ahmedabad versus Jan Mohammad Usman Bhai. Your Lordship, in this particular case, it was held that the term "in the interest of the general public" is one that is of an extremely wide import and also includes public health under it. Your Lordships, in the present case, both the Amendment Act issued by the Union of Diana as well as the regulation issued by the state of Haryana have a great concern with reference to public health. And additionally, both pieces of legislation have been subject to a large amount of public criticism. Therefore, Your Lordships, it is submitted that ensuring that both these pieces of legislation do not affect fundamental rights is something that is most definitely in the interest of the general public at large. Another
Counsel,
caveat. Yes.
can we make a note of the fact that you're admitting these legislations are primarily to do with public health? It may be of relevance to your subsequent issues.
Yes, Your Lordship, these legislations we do believe are with reference primarily to public health and improvement of the same. Much obliged, Your Lordship. Your Lordship, one final point I would like to make with reference to the maintainability of this petition is with specific reference to the case of Roop Chand versus the state of Punjab, wherein it was held that a PIL can be filed not just once fundamental rights have been violated, but even on the pretext of a threat to fundamental rights down the line. As such, similarly in this case, Your Lordship, while to a certain degree the petitioners do believe that Mr. X's rights, as well as the rights of certain citizens in the state of Haryana, have already been violated, even if the court does not agree with that particular case, the threat of fundamental rights is enough to file a PIL with reference to the same. Your Lordships, if there are no questions with reference to this particular aspect of maintainability, may I move on to my second contention?
Counsel, I have one question about maintainability. I see that you have combined both claims in a single petition. Why should the claim against the constitutionality of Haryana's law not have been more properly brought in the High Court of Haryana?
So, Your Lordship, I would like to answer this particular question on two prongs. Firstly, with reference to why the High Court's jurisdiction under Article 226 was not first approached. Your Lordship, firstly, considering the fact that the regulation of the state of Haryana puts a bar on interstate travel, that would put certain people who are affected by this particular regulation outside the jurisdiction of the High Court of the state of Haryana. Additionally, Your Lordships, in the case of Romesh Thapar versus the state of Madras, the Supreme Court was regarded as the protector and guarantor of fundamental rights, and it was held that they cannot refuse to entertain applications seeking protection against infringements simply due to an alternative remedy in the High Courts being available. Lastly, Your Lordship, as to why we have interlinked these particular petitions. Your Lordship, seeing the fact that the Epidemic Amendment Act, on the face of it, is one that provides immunity to vaccine manufacturers, whereas the regulation issued by the state of Haryana is one that makes it mandatory to a certain extent for people to take those particular vaccines. Clearly, we believe that the court should address both of these simultaneously, and as such should issue a verdict keeping both of these particular pieces of legislation in mind. Lastly, Your Lordship, the Supreme Court, we do believe, is the appropriate authority here, considering the fact that in the current situation, time is most definitely of the essence. And as such, the Supreme Court would be the appropriate authority to approach. If that satisfies Your Lordship's question.
Who are you appearing for? Just the petitioner, the NGO, and there are no other petitioners, right?
Your Lordship, there is
No
only the
individuals,
NGO
there's
as the
nobody else.
petitioners. Nobody else, Your Lordship. Much obliged, Your Lordship. Your Lordships, if it's all right, may I move on to my second contention?
Yeah.
Much obliged, Your Lordships. So, Lordships, with reference to the Epidemic Amendment Act.
Sorry. There is no other party to the petition. You have not even avowed that the other members of your associations are citizens, right? Have you avowed that?
Your Lordship, could you just repeat the question, please? It got cut off in the
You've
middle.
only made the NGO as a party. Have you actually referred to the members of the NGO, whether they're citizens or not? You're coming by way of 32. You can only invoke fundamental rights.
Yes, Your Lordship. So, Your Lordship, in the present case, the NGO is one that is based in the Union of Diana itself. And as such, we do believe that they do have the requisite locus standi to file this particular petition before the Supreme Court under Article 30.
That's
Additionally, Your Lordship.
What are the fundamental rights you're invoking?
Yes, Your Lordship. So with reference to that, Your Lordship, considering the fact that as the petitioners in this particular case, we believe both pieces of legislation violate Articles 14, 19, as well as 21. Additionally, Your Lordship, in the present case, considering that these articles are of an extremely wide spectrum, and the pandemic, of course, is something that would affect each and every citizen, the legislation issued with reference to that would also do the same. Therefore, Your Lordship, it is submitted.
Have you made a citizen a party or not?
No, Your Lordship, we have not made a citizen a party in this.
That goes to the
case.
maintainability.
Exactly.
Isn't it?
So, Lordship, with reference to that, I would like to bring your attention to the case of Mr. X in this particular scenario. While, of course, he has not been made a party, considering the legislation was actually issued after his case was already pending before the Supreme Court. Lordship, his case is one that perfectly shows how people would be affected by this particular piece of legislation.
But you're not
Seeing that
making
the
a party.
Your Lordship, we have not made him a party to this particular petition.
Okay, thanks.
Much obliged, Your Lordship. Lordship, may I move on to my second contention?
Yeah.
Much obliged, Your Lordships. So, Your Lordships, with reference to the Epidemic Amendment Act itself, I have three major submissions before the court today. Firstly, I will be attempting to show that the Epidemic Amendment Act suffers from the vice of vagueness. Secondly, I will be showing that the legislation is manifestly arbitrary. And lastly, I will be showing that the Act fails to satisfy two key prongs of the test of proportionality, which has been established as the best practice judicial method to balance state interest against individual liberties and rights. So, Lordship, that brings me to my first submission with reference to the inherent vagueness that is present in this particular Epidemic Amendment Act of 2021. Your Lordship, as per the landmark judgment in the case of Shreya Singhal versus the Union of India, it was held that a provision would be considered as vague if no demarcating line could be drawn between the usage of certain terms which are enshrined under the Act. Additionally, in the United States case of Connolly versus General Construction, which has also been adopted by Indian Supreme Courts, it was held that a provision is considered as vague if a man of common intelligence would not be able to understand it. Your Lordship, in the present case, I would like to bring your attention to Clause 5, Subclause 1 of the Amendment Act, which is present in Annexure 8. I hope my lords are with me on this.
Yeah, go.
Wherein, Your Lordships, it is mentioned terms that such as serious physical injury and willful misconduct have been used. Your Lordships, it is submitted that these terms are such that they do not have any clear definition within the parameters of this particular Act, and additionally have been left in a completely open-ended manner with a severe lack of specificity. Moreover, Your Lordships, the lack of any demarcating line in this particular regard would make it impossible for any victim of side effects or any common man for that matter to be able to distinguish whether his injury would qualify as one that is a serious physical one or whether there would be any willful misconduct on the part of the vaccine manufacturers.
If I can
Your
ask a
Lordships,
question, Counsel,
Yes,
just on this point. You mentioned that, the facts very clearly say that there's no clarity on what are the side effects of these vaccines. If there is a lack of clarity on what side effects exist, how would you expect the legislators to draft serious physical injury any more specifically?
So, Your Lordship, in fact, that is our exact point, is that the fact that they have given immunity and in fact prevented any form of liability with regard to these particular vaccine manufacturers while not knowing what the side effects are is something which is done very prematurely and should not have been done in the first place. So, Lordship, with
Serious physical injury is in the, sorry, I don't mean to argue, but the serious physical injury is in the proviso which fixes liability. So is that not better for the public at large?
Your Lordship, we don't believe that because one more aspect of the vague nature of this act is that they have not placed a burden of proof on anyone. So, Lordship, over here, while we do understand that serious physical injury may be construed by different people in a different manner, there is nobody who would be regarded as the authority to decide if an injury qualifies as a serious physical one or not. As such, Your Lordship, I would like to bring your attention to the case of Vasantlal Maganbhai Sanjanwala versus the state of Bombay, wherein it was held that if a legislature lays down its policy in vague terms, arbitrary powers would be conferred onto the executive, leading to the end of the doctrine of law. Your Lordship, we believe there is nobody who is regarded as the authority to decide if an injury qualifies as a serious physical one. Your Lordship, I apologize. I can't hear the question very clearly. Santal Maganbhai Sanjanwala wherein
I think
Your Lordship, I cannot hear you, Your Lordship. The voice is cracking quite a lot. I don't know if this is my internet or.
It's the YouTube transmission that is happening that's feeding back into this. Go.
Your Lordship, should I move on in
Yeah,
the meantime?
now you can.
Yes,
Now we've
please.
lost
All right. Much obliged, Your Lordships. So, Your Lordships, therefore, we do believe that the vagueness which is inherently present in this particular act is one that confers arbitrary powers onto the executive. As a result of the same, this particular act should be struck down for such arbitrary usage of terms. Your Lordship, that brings me swiftly to my second submission, which is the manifestly arbitrary nature of the compensation structure which has been implied in this particular piece of legislation. We believe, Your Lordships, that this is a clear violation of the right to compensation, which has been decided by the Apex Court itself to be a corollary to Article 21. Your Lordships, in the case of Shaira Bano versus the Union of India, it was held that manifest arbitrariness was defined as an act of the legislature that is done without an adequate determining principle. Additionally, in E.P. Royappa versus the state of Tamil Nadu and another, it was held that equality is antithetic to arbitrariness, and as such, an arbitrary action would most definitely fall flat in the face of Article 14. Your Lordships, with specific reference to the compensation structure that is enshrined in Section 6 of the Amendment Act, I would like to firstly emphasize that the Apex Court has also held monetary compensation as a remedial measure that can be implemented for victims whose fundamental rights have been infringed. And furthermore, with specific attention to Section 6 of the Act, it is mentioned that compensation will be provided to victims of side effects up to 30 lakhs. However, my lords, it's submitted that in this particular case, no adequate determining principle has been provided with regard to the calculation and computation of the compensatory amount itself. In the case of State of Gujarat versus Shri Shantilal Mangal Das, Your Lordships, it was held that computation of compensation, if based on illusory principles, cannot be held as valid, since that would be tantamount to granting a charter of arbitrariness. In the present case, Your Lordship, such a lack of adequate determining principles clearly shows that the Act does suffer from manifest arbitrariness and should be struck down as a result of the same. Furthermore, Your Lordships, with reference to the case of Sarla Verma and others versus Delhi Transport Corporation and another, it was held that any compensation assessment must be objective, consistent, and based on a plethora of legal principles in order to be considered as just. In the present case, Your Lordships, this severe lack of any legal principles would most definitely lead to arbitrary and non-uniform calculation of the compensatory amount by the government.
But isn't this a little presumptuous, Counsel, because Section 6 does indicate in a manner as may be prescribed? You haven't seen those rules yet.
So, Your Lordship, with reference to that aspect of Section 6, on a clear reading of it, Your Lordships, it is written that they may seek compensation from the central government in such manner as may be prescribed. However, Your Lordships, it is submitted by the petitioners that this simply deals with the modalities of how a person would approach the central government, but would provide no information with reference to how compensation will be calculated by the central government. Your Lordship, with reference to that, seeing the fact that the legislature, at least as of now, has provided no adequate principles on how this compensation would be created, it is submitted that there is a clear lack of any adequate determining principle. Additionally, Your Lordships, in this particular case, seeing the fact that the central government is the authority to approach, and along with that, the central government is the one procuring the vaccines and the central government is the one paying the compensation, clearly this is bound to lead to arbitrary action if legislative guidelines are not given regarding how compensation is meant to be calculated. My last point was reference.
Counsel, if couldn't a court action conceivably be brought against the government to recover the compensation, and wouldn't the courts be qualified to fill in some of the details for calculating damages, which you've been alluding to in a way similar to how courts do in tort actions and other actions for remedies?
So, Your Lordship, I would like to answer your question on two prongs. Firstly, with reference to the 30 lakh cap that has actually been implemented in this particular case, Your Lordship, it is submitted that if principles are not provided with reference to how compensation is calculated, there are also no principles with reference to how this 30 lakh amount has been reached. And additionally, that cap must also be reasonable in nature. Your Lordships, in previous medical negligence cases, 11 crores and 14 crores has been given as compensation to victims who have suffered as a result of medical negligence. And in this particular case also, a similar amount should be prescribed, or the government should provide necessary measures on the basis of which they have reached the 30 lakh figure. Additionally, Your Lordships, with reference to why the central government itself cannot be approached with reference to the compensatory amount is with reference to clause 5, subclause 2, where it states that no civil court, tribunal, or authority shall have jurisdiction to entertain any suit or proceedings in respect of the immunity granted. Your Lordship, as a result of that, it is submitted that the particular compensation given by the central government is not one that can be challenged. And with reference to the same, I would like to bring your attention to the case of Kesavananda Bharti, wherein it was held that when a compensation amount is provided, the amount of the compensation itself cannot be challenged, but the principles which cause the computation of the compensation are meant to be challenged before the court. However, Your Lordships, here there are no such principles which have been prescribed, and therefore any person who has suffered side effects and wishes to challenge their compensatory amount cannot do so because he himself would not know on what basis the compensation amount was calculated. If that satisfies Your Lordship's
in the
question.
Kesavananda Bharti case, how much compensation was awarded?
Your Lordship, I must plead my ignorance with reference to that. I don't know that.
So you're asking us to rely on Kesavananda, but you don't know what the compensation was and what the computation was. Okay.
So, Your Lordship, simply in that particular case, the reason why we're mentioning it is just on the basis of the principle that was adopted and not the facts of the case itself of how compensation was
I agree
decreed.
with you. If the principle was adopted, you should know what came out of it. Applying that principle
Apologies for
in
the
the
same,
Kesavananda case, what did the court grant? If you
Apologies
claim it's
for
a
the same.
principle, we must see the outcome. I put it to you that that is not the principle in Kesavananda. You've just picked a random paragraph. Now you tell me why it is not a random paragraph by showing me the compensation.
Your Lordship, if I could just have a second to pull up the judgment, if that would be all right.
You can, but you're not going to find it.
All right, Your Lordship, if I could just move on to my next submission then, if that's all right.
I mean, if you're planning to turn pages on Kesavananda Bharti, we'll be here next week.
Definitely, Your Lordship.
Yeah.
So, Your Lordship, my final point with regard to the Amendment Act and its manifest arbitrariness is with respect to the lack of any expiry date present within it. Your Lordship, in the present case, this immunity, as admitted by the central government itself, is something that has been provided to encourage vaccine manufacturers to produce vaccines and encourage them to focus on development of the same. However, this immunity as a result of that should only last until the vaccine doses have been procured rather than be carried on indefinitely. So, Your Lordship, in the present case, the legislature has once more let an abdication of power since there are no guidelines on the.
What do you mean it goes on indefinitely?
So, Your Lordship, with reference to that, what the petitioners are essentially claiming is that it has been stated in the Act itself that the central government, by way of notification, can provide immunity to any vaccine manufacturing company at any point in time. Yes. However, Your Lordship, there has been no procedural safeguard with reference to what basis or what principles would be used and what the situation requires for the central government to do so. As such, Your Lordship, it's submitted that this renders an excessive power to the government with no safeguards in place to prevent it if there was any misuse down the line. Your Lordship,
a potential misuse of a legislation is a ground for us to strike it down?
Your Lordship, this simply adds to the initial contention of the fact that there is a lot of manifest arbitrariness which could at least be misused down the line.
I'm asking a simple question. You're saying a potential misuse of legislation is a ground for it to be struck down under Article 32?
No, Your Lordship, we are not stating that a potential misuse is that. It's simply that if we are suggesting that this particular legislation does have issues within it, this would be one of them.
But
it's simply
it has an issue, but no court has ever said that potential misuse of legislation is a ground for striking down. So give me another
Your Lordship,
ground.
the only reason why stating this, Your Lordship, is because it renders an excessive power to the executive in this particular regard. And as such, down the line could be viable to be misused by the same.
So then you come to us.
All right, understood, Your Lordship. So if I could just move on to my final submission with respect to the Amendment Act.
Actually, Counsel, would you mind if I circle back to one thing you said earlier? I've still been thinking about it. I think you said that Section 5(2) would preclude a court from hearing an action under Section 6. But as I'm reading it, doesn't Section 5(2) relate to suits against developers and manufacturers, whereas Section 6 is a separate basis for an action to be brought against the central government?
So, Your Lordship, with reference to that particular question, I believe the Kesavananda Bharti case was going on with reference to that. However, in Section 6 itself, there has been no mechanism being described under Section 6 as to where a particular and challenge the compensation amount which has been provided to him by government. Such Lordships, it's submitted that such a read into the Act is provided for by the legislation itself. If that satisfies Your Lordship's question. Much
Why
obliged,
can't
Your
you file a
Lordship.
suit against the central government? I think the question we're asking is, why can't you just file a suit against the central government and claim the money? What stops you? Is there anything in the CPC that says you can't do it?
Your Lordship, I'm not entirely sure with reference to the CPC. However, in this particular case, Your Lordship, the petitioners are of the belief that the government would be protected under sovereign immunity provided to them, seeing that this particular act is being carried out in exercise of a sovereign function. As such, the government would be
What
protected.
is the
and
sovereign?
secondly-
What is the sovereign act and sovereign function here?
So, Your Lordship, the sovereign function over here is the fulfillment and pursuance of improvement of public health, which would qualify as a sovereign function of the government. As such,
Okay.
suing them for the same, Your Lordship, would be against that idea. If
And
that
which
satisfies
provision
Your
of the
Lordship-
CPC says you can't sue the government on a sovereign function?
Your Lordship, I must speak my ignorance with reference to that. I'm not.
So you're making a claim that it's a sovereign function. You're making a claim that a government can't be sued, but you can't tell me which piece of legislation says the government can't be sued. Okay,
Your Lordship,
should move on.
Your Lordship, if I could move on to my final contention.
Yeah.
Much obliged, Your Lordship. My third submission is with reference to the fact that this Amendment Act fails to satisfy two key prongs of the test of proportionality, which was enshrined under the case of Justice K.S. Puttaswamy versus the Union of India. Your Lordship, the first prong is with reference to the fact that no rational nexus exists between the means adopted and the objective sought in this particular case. Your Lordship, I'm seeing that my time has elapsed, so may I have, in the interest of justice, a 4-minute extension?
No, you can have a minute.
All right,
You
Your Lordship, I'll
finish
just
your
quickly
proportionality.
summarize my
Tell us
last
what the
statements.
disproportionality is and stop.
Most definitely, Your Lordship. So, Your Lordship, I would like to point out point 15 of the fact sheet, which in this particular case states that public turnout for the vaccine is extremely low. Your Lordship, this has happened after almost a month and a half of this particular act, which was meant to encourage the public and actually get the vaccines procured from the manufacturers to ensure quicker vaccination of the public. However, Your Lordship, seeing that the objective, as I previously stated, was improvement of public health, it is submitted that that has not happened regardless of this legislation, because the public, despite the legislation being enacted, is not coming to take the vaccine, and therefore public health is not getting improved regardless of procurement of the vaccines. Therefore, Your Lordship, it is simply submitted that a rational nexus in this particular case does not exist between the means that have been adopted and the objective that has been sought. My last submission, Your Lordship, is with reference to the second aspect of proportionality, that is the existence of a less restrictive, equally effective measure. In the current case, Your Lordship, as per Anita Kushwaha versus Pushap Sadan, Your Lordship, it was held that the right to access to justice and right to adjudicating mechanisms is something that is a corollary to both Articles 14 as well as 21. In the present case, Your Lordship, denial of the same would reduce Article 14 to a mere teasing illusion. In the present case, Your Lordship, Section 5, subsection 2, as previously mentioned, removes the jurisdiction of the court to try such cases. And I would like to bring your attention to the case of the United Kingdom, which in the face of a similar pandemic of a similar nature and magnitude, enacted the Vaccine Damage Payments Act, which provides a tax-free compensation of £120,000 to a person who suffers from vaccine side effects. However, The key differentiating factor between what was enacted there and in the Union of Diana is that in that particular country, the compensatory amount, if not agreeable to the victim, was challengeable and a redressal mechanism was available to a tribunal. And that same thing was enshrined within the act and piece of legislation itself. As such, Your Lordship, under Article 247, the Parliament has been given the power to set up additional courts for better administration of legislation. And as such, Your Lordship, I would like to conclude my arguments if there are no further questions from the bench. Much obliged, Your Lordships. It's been a pleasure arguing before you. Thank you.
My lords, before I begin, I would just like to seek a clarification from the bench that recently there has been a pertinent judgment by the Meghalaya High Court, which assumes great significance in the matter. However, I must tell the court that this judgment was passed only after the submission of written pleadings by both sides. So I will cite it in my arguments only if your lordships permit me to. Otherwise, I'm prepared to argue without it.
No, go for it. You can cite anything you like.
Very well, my lord. So if I may begin. May it please this honorable court, I am counsel S2, appearing on behalf of the petitioners in the matter of Freedom for All versus Union of Diana and the state of Haryana. As stated previously by my co-counsel, I will be dealing with the third contention here today, which is that the regulation passed by the state of Haryana mandating vaccinations to its citizens is unconstitutional and ultra-virus to the Epidemic Act. I will be basing my arguments on two prongs. The first, that the said regulation has been passed beyond the scope of the legislative authority given to the state government under the Epidemic Act, thus making it ultra-virus to the Act. And secondly, my lord, and even if we disregard this preliminary objection of ours, I will go on to satisfy that the said regulation is inherently unconstitutional. My lords, coming to the first point, that the said regulation is ultra-virus. As per a reading and a plain reading of Section 2 of the Epidemic Act 1897, it is clear that the state government is empowered to take temporary measures as it deems fit to curb the spread of the pandemic. Here we submit that the word temporary assumes great significance. It has been defined by Black's Law Dictionary to involve anything that is not perpetual or indefinite in its duration. Furthermore, my lords, the Supreme Court, in the case of Krishna Kumar Singh versus State of Bihar, has stated, and while the facts of the case I must tell your lordships is to do with an ordinance, the principle espoused is that when any temporary power has been given to an executive, such a temporary power, which is for a limited period of time, must never be used to bring about changes which ultimately have a permanent effect. They have gone on to
Yeah,
hold.
but that's not the story here. It is not the power given to executive, right?
My lords, it is our submission that the Epidemic Act by its very nature is something which is intended to last only for the duration of the time that a pandemic is raging in the country. And we believe that any regulation that has been issued by the state government under the Epidemic Act must also have effects that last only for the duration of a pandemic. Now, it is our submission that in the present scenario, by mandating vaccinations, the state governments are ultimately mandating an activity which will have a permanent effect. My lords, what the state government is doing.
What I don't understand. What are you suggesting the state should have done?
My lords, as I will go on to prove in my next point on unconstitutionality, that there are various other less restrictive but equally alternative measures that are available in the present case, but have not even been contemplated by the state government. And I will go on to prove that to my lords under Article 14. If I may just quickly wrap up this argument and I'll move on.
I'm not understanding this. What are you claiming is permanent?
Precisely, my lords. By mandating vaccinations, my lord, when a vaccine is injected into a body of an individual, and the Supreme Court has stated that anything that is irreversible is permanent in this effect. My lords, if there is a situation in which the vaccination ultimately causes death or the vaccination causes serious physical injury that cannot be reversed, such a permanent effect has been carried out by the exercise of a temporary power itself. And my lords, even if we disregard this, and if my lords may see Annexure B itself, it is clear that the restrictions that have been imposed today, there has been absolutely no end date that has been prescribed, and it has been left open-ended, making it indefinite in duration, which is antithetical to the very definition of temporary, as there must be some sort of
I agree with
Counsel-
all that you have said. Just explain this to me. According to you and your friends, the experts, when does the pandemic finish?
My lords, in the present scenario, the pandemic, there's no clarity on when this pandemic will get
So
over.
how do you expect the government to have an end date?
My lords, we simply submit that if such a restriction has been given, you can provide an end date for the regulation, and if the government deems fit, after that the regulation can be further extended for a period of time.
Then you will come
making
back and say it's misuse of powers. That's exactly what happened in Krishna Kumar, where they kept using this power to extend. Now you're citing that case to me and saying you have an end date and keep extending. That was the exact facts of the case that you are citing to me to say it should not be done.
My lord, the reason that it is slightly different from Krishna Kumar Singh in our opinion is because in that case, the Supreme Court has held that repeatedly enacting ordinances is a fraud on the Constitution. I agree.
It's the same
But
thing.
my lords, in the present case, we believe that this subordinate legislation, which is simply carrying out regulations under a parent statute, is different from the inherent nature of an ordinance itself. And therefore, we are simply stating that these said regulations can be extended. But, my lords, in any case, even if we disregard this, I believe that the said regulation is inherently unconstitutional.
And why, counsel, do the words "until further notice" not suffice? Doesn't that
Yes.
suggest that the state has authority to step in and give notice that this power is terminated, similar to terminating a declaration of a public health emergency? What would be the distinction?
Yep.
My lord, I appreciate, and the only reason I was basing my point on that is we submit that even the words "until further notice" still technically renders the restriction as indefinite. But in any case, my lords, this was just a preliminary objection. And even if it disregard this,
Can I ask a question? Are you suggesting that during the so-called temporary period, they cannot resort to vaccination without consent? Is that your real issue? Let's come to the basic issue. Is that your real issue?
precisely, my lord, and I will go on to just
So
state
what's the
that.
substantive issue? How is temporary and permanent related to that?
My lord, the reason for temporary and permanent was
If it is necessary for a public health emergency to resort to vaccination, these arguments pale into insignificance.
I appreciate, my lord, and therefore I will move on to the substantive merits. And I will be basing my arguments that the said regulation violates constitutional principles on three grounds. Article 21, the right to life, Article 14, and it imposes unreasonable restrictions on Article 19. Now, my lords, coming to my first argument on Article 21, the right to life, which has been laid down by catena of judgments to imply a term of the widest import. The petitioners submit that in the present case, two essential rights under Article 21 has been violated. The first, the right to refuse medical treatment, and the second, the right to informed consent of an individual. Coming to the first prong, my lords, it has been stated in the case of Aruna Shambag, and the principle has been laid down that the principle
But
of
that was not in the
self-determination.
case where there was a public health emergency which may override an individual's non-consent. That's not relevant here. We understand that consent is required in individual cases. Please argue whether in a public health emergency, consent can be overridden or not. That's the crux of the question.
Very well, my lord. And just before going to that, I would like to answer your point that the Supreme Court recently, in the case of redistribution of essential supplies, has held that even in a pandemic and even when actions have been taken in the supposed promotion of public health, every enactment must be tested on the principles of violation of principles of proportionality, arbitrariness, and the right to life. And furthermore,
You're on consent. It's slightly different. Consent is a slightly different issue from what you have alluded to. You're talking,
my lord,
consent can be overridden by a statute if it is otherwise constitutional. You know that. Consent is a common law principle which can be overridden by a statute. But it has to actually satisfy the test of constitutionality. There is no doubt about that. So,
indeed, my lord. And therefore, I will move on straight to my arguments on right to freedom under Article 19. And I will try to prove to my lord.
how can you argue 19, Mr. Counsel? You have not made a citizen a party. It's only available to citizens. Your petition is not maintainable on that ground.
On 19. And that's why we asked you that question at the
14
beginning.
and 21, yes. You can argue on 14 and 21, but 19, you can argue, but there's a maintainability issue on that.
My
Tell
lords, I
us why.
appreciate. Sorry, my lords.
Tell us why.
My lords, I appreciate that in the present case, we have erred in not attaching a party so that we can, so we can't address Article 19. But if I may have my lord's permission, I would still like to state our objections as per 19 and leave it to the wisdom of the court to take it into consideration as they deem fit. So, my
You
lords,
can try, but the answer to the question is Bennett Coleman and Sakal newspapers.
Oh, very well, my lord. I will keep
Posted
that in
judgments.
mind.
Yeah.
I will
So
keep
those are the
I'll
two
keep-
judgments which have helped you to answer the question. But go ahead. Let's hear what you have to say on 19.
Yes, my lords. Under Article 19, which is the right to freedom, we do concede that under the right to freedom of movement and trade, certain reasonable restrictions can be placed in the interest of public. However, these restrictions must imply, as stated by the Supreme Court Chintaman Rao, to imply intelligent care and deliberation, and they must have a nexus to the reasons for the restrictions. Now, before I go into the merits of the same, I must bring to the court's attention the recent judgment of the Meghalaya High Court, which has stated two important things. The first, that mandatory vaccination itself is antithetical to every principle of the Constitution, the major principles under 21 and 19. And further, they said especially that when vaccination is being placed as a condition for people to access their occupation and trade and earn their livelihood, then it can never be classified as a reasonable restriction for the same. My lords,
The
as in the
second argument appeal to the court there. That's the second argument, not the first one. Second argument is actually appeal to the Meghalaya High Court. Yes.
sorry, my lords, you had got cut off.
Your second point that you made, appeal to the Meghalaya High Court. You can't make it a condition for the right to earn a livelihood. That's the most poignant point. First point, I don't think has much merit.
Very well, my lord. So in the present scenario, we submit that what the said regulation is doing is it is placing the people of Diana in a very unsafe dilemma. Ariana, my apologies, in an unsafe dilemma. On one hand, to take vaccinations, which may potentially be a death sentence mandated by the state, or on the other hand, to access their basic right to go to their offices, to go to their factories, to earn a livelihood, which is also a means for their very survival. And such a restriction which places the people in an unsafe dilemma can hardly be classified as a reasonable restriction, but we
Has
submit
there
that
been
they are.
any other instance in the past where people suffering from certain diseases have been excluded, externed, interned, placed in sanatoria?
Sorry, my lords, could you just reiterate that question?
Have there been instances in the past where, on the grounds of public health, particularly infectious and contagious diseases, where people have been excluded from public spaces?
My lords, there has been, and I must be honest with my lords, that when there was a cholera epidemic in India, there was a regulation in the state of Orissa which stated that just for that particular district, people may not move around without vaccination. However, no court has gone into the merits of that, and there has been only one case, which is J. Chaudhary versus State of Orissa, which expressly stated that the court is not going into the safety of vaccinations and the legality, but they are just dealing with one offender who was disobeying the regulations. So therefore, there is some history as to where this has happened, but no court has effectively decided on the issue as of yet.
Now, what
And my
about tuberculosis?
No, there's
My
a
lord-
judgment of the Goa bench, which I argued, Lucy D'Souza, in the HIV case. Please see that. That's why I think Murli referred to sanatoria. I'm not sure whether he meant this
Yes,
case.
yes, Anand, yes. I do my own research, thankfully.
I know. I can see that. No, but I'm just telling you that you use the phrase sanatoria. So, and that judgment actually is a wrong judgment. But in any event, there is a judgment, well-reasoned
But
judgment.
we also have it in the TB cases. So that is the
Yes,
question I
yes.
wanted to ask you. We have you mentioned cholera, but I want you to answer for TB. I want you to answer before that for leprosy, and then obviously HIV.
My lords, I must submit that in the present case, I have not gone to the modalities of various other diseases. We have simply researched on COVID-19 itself. And therefore, I must plead my ignorance to this matter. But if I may
Go on.
just state my last point under Article 19, which is that reasonable restrictions can only be placed in public interest. And this may be a small point, but it's of great significance. That as per the Moot proposition itself, para 16, the regulation issued by the state of Haryana is one which has been received with huge public criticism and people are outraged by it. It is clear that the very the very public for whose interest these restrictions are supposedly placed for are the same people who are rejecting such a regulation and are opposing it. Now, my lords, if I may come
Is
to
that a
Article
legal
50,
ground? Is that a legal ground, popular sentiment?
my lords, that's why I initially stated that's a very small point, but we believe that must be taken cognizance of by this court in making that decision. Although it is not a legal principle that states that public sentiment should not be taken, we believe it is an important factor in this case, and the Supreme Court has always held that the surrounding circumstances must always be seen to see a legislation. If I may,
How is 19 being invoked in this context?
so I apologize, my lord. Could you repeat that
Oh,
question?
you are actually addressing arguments on Article 19 now, right?
Yes, my lords.
How is it connected to your argument?
My lords, we believe that to establish whether these restrictions are actually have a reasonable nexus for the reasons for the restrictions, we must
What is
believe
the
that whether
reason? Not to spread the infection, but I think your argument on proportionality is what has to be argued now. What your
precisely
other counsel had argued, but he didn't address this point.
Precisely, my lord, and therefore I was coming to Article 14, as we believe that the said regulation is one of two things. It is arbitrary and it is excessive. Now, coming to the fact that it is arbitrary, the Supreme Court has held that that arbitrariness is a very antithesis to equality in EP Royappa. Now, there are certain terms that have been used in the said regulation, which, such as the enforcement authorities must take all necessary measures in a supposed just and humane manner. Now, my lords, there is no parameters as to what the guidelines as to how the enforcement authority should enforce their duties. There are no
Would you
binding.
rather they act inhumanely? Would that be to your preference?
Certainly not, my lord. However, I certainly do believe that the vagueness of this term opens it up to misuse by the enforcement authorities, as we must keep in mind that under the Epidemic Act itself, authorities are given immunity for actions done in supposed good faith, and therefore all of these parameters put together render it open to the misuse of by enforcement authorities. And coming to my argument of proportionality, as my lord wished I would, in Justice Puttaswamy, it has been held that if there is any other equally effective, less restrictive measure available, then the said regulation must be categorized as disproportionate. Now, my lords, a WHO report on mandatory vaccination has clearly stated that before the policy makers even contemplate going into mandatory vaccination and employing a restriction that is so restrictive, they must try less restrictive measures, such as actually providing incentives for vaccination, actually demonstrating their safety. Now, my lords, in the present case, and as seen in the fact sheet, neither of these have been done. And even despite of these, my lords, we believe that there are certain basic counter-pandemic measures that must be first implemented, such as preventing people from intermingling in public, and none of these have been done. So even without the government actually attempting less restrictive measures, they have jumped the gun and tried to directly force vaccination onto the people. And furthermore, my lords, we submit that the present regulation creates certain unreasonable classifications that have no nexus to the objective. Now, while we agree that para 15 states of the Moot proposition, the Chief Minister himself has stated that the objective is to achieve herd immunity. We must state that the respondents have come forth in a memorial in para 33 and stated that the objective is also to prevent spread of the virus in the workplace. My lords, the basic question here today is why in Annexure B have even the workplaces been discriminated between? Why is there a classification between those who attend commercial establishments, such as offices and factories, and those who work in non-commercial establishments, such as shops, marketplaces, or even offices of NGOs? My lords, even these are very susceptible places for the spread of a virus, but yet they have not even been restricted by the said regulation, but only commercial establishments like offices and factories have been restricted. Furthermore, even amongst the essential supplies that have been exempted by the said regulation, they have exempted only a certain category, such as food and dal manufacturers and medicine manufacturers. However, we submit, my lords, that there are a number of other essential supplies that are absolutely crucial to the day-to-day survival of people, and that is essential for the functioning of a modern society. Supplies
But
are
counsel, that can't be the basis for striking down the notification. You can write to them and request them to extend it. And for whatever it's worth, they've used the beautiful word, etc. at the end. You fit everything in the etc.
My lords, we certainly believe that just by using the word etc., that in fact creates more confusion in the matter. And we do believe that time is of the essence. And over here, when we sit, we ask the government to maybe enact it, the government to take into under consideration. While all this is going on, the process of coercing people into taking the vaccination by these restrictions has already begun. And there's only a 1 month period that has been provided by these regulations so that people may take vaccinations. And my lords, as I see that my time has elapsed, if there are no further questions by my lords, I may just come to one last point.
Before you do, I will request you to address something, or you can choose to ignore it. You mentioned reference to the memorials. Your memorial refers to something on 246. Your fellow counsel, I think he overshot time. So should we presume that you're not raising 246 as a ground at all, or something to do with the 7th schedule? Not interested in that.
My lords, when it comes to the separation of powers between the center and the state,
Feel free to not raise it. We're happy to let you drop it.
my lords, we are not pressing it right now as we believe that the Epidemic Amendment Act already violates other prongs of proportionality. If I may just come to my last point, which is a violation of right to life under Article 21. As I stated earlier, I must tell the court in all responsibility that we admit that Article 21 can certainly be restricted in certain cases. However, this restriction can only be employed by a procedure established by law which is fair, just, and reasonable. And keeping in mind the flaws of Article 14, keeping in mind the flaws of Article 19, which this regulation possesses, the state government certainly cannot come forth and say that what we are doing is to preserve the right to life of the many. What we are doing is to preserve the right to health of the many, as this is that same state government that doesn't even have enough hospitals in their country to actually cater to its people. And therefore, we believe that this excuse of preserving Article 21 and that this procedure established by law is a just reason to restrict Article 21 is something that is nothing more than an excuse to cover up the state government's own inadequacies. And here, my lords, I will rest my submission and I would like to thank the court for a patient hearing.
Thank you.
Thank you, my lords.
The council solicits permission to begin and to address the bench collectively as the bench and the honorable judges as your lordships and ladyships respectively. Much obliged, your lordship. Greetings to the bench. May it please the bench, myself and my co-counsel will represent the respondents in the case of Freedom for All versus the Union of Diana and another. I will be taking 22 minutes of the honorable court's time, and my co-counsel will be taking 21 minutes of the same, reserving 2 minutes for rebuttals. May it please the bench, I would like to move forward with the statement of facts.
No, we know the facts. Can you get to what your first issue is?
Indeed, your lordship, there are three major issues before the honorable court today. The first issue is whether the writ petition filed by Freedom for All under Article 32 of the Constitution of Diana is maintainable. The second issue is whether the Epidemic Amendment Act 2021 is violative of Part 3 of the Constitution of Diana. The third issue is whether the regulation issued by the state of Haryana is unconstitutional and ultra vires to the Epidemic Act 1897. I will be dealing with the first two issues, whereas my co-counsel will be dealing with the third issue. Lordship, with this, the council would like to move forward with the first issue. It is submitted before the honorable court that the writ petition filed by Freedom for All under Article 32 of the Constitution of Diana is not maintainable. Your Lordship, this is further argued in two sub-contentions. The first sub-contention is that the petitioner has an alternative remedy available under Article 226 of the Constitution of Diana. The second sub-contention is that the petitioner has raised several questions of facts rather than questions of law. Your Lordship, firstly, I would like to move forward with my first sub-contention that the petitioner has an alternative remedy available in Article 226 of the Constitution of Diana. Your Lordship, the High Court of in the case of P.N. Kumar versus the Municipal Corporation of Delhi, the Supreme Court held that if the remedy can be granted by the High Court, then it is preferable that the petitioner approaches the High Court. The courts also held that each High Court has its own high traditions. They have judges who have the initiative, necessary skills and enthusiasm, and their capacity should be harnessed to deal with every type of case arising from their respective areas, which they are competent to dispose of. Thus, your lordship, this is not a mere suggestion, but the Supreme Court itself held that this will also benefit the Supreme Court, as the process of the SC, the Supreme Court taking the case as an original jurisdiction, which is a time-consuming process which can be avoided, and also the Supreme Court will benefit from the decision of the High Court when it comes under an appeal, your lordship. Thus, it is both advised by the Supreme Court and considered for the benefit of the Supreme Court that it goes to the relevant High Court first. And also, the Supreme Court, in the compilation of guidelines to be followed for entertaining letters, petitions received in this court as public interest litigation, have specifically stated that matters which can be dealt with by the High Court or any other authority may be sent to them without any comment whatsoever, instead of all such matters being heard judicially in this court only. And thus, it would be in the best interest of justice and the benefit of the Supreme Court for the petition to be heard by the relevant High Court. Your lordship, moving forward, the petition.
Are you arguing that this should be dismissed on that account?
Your
On that
lordship,
account, are you saying that the petition is it has to be dismissed because they can approach the High Court?
your lordship, it is suggested to the Honorable Court.
The argument you're posing is actually traditionally used in when a person approaches under 226 when there's an alternative remedy.
Correct.
Not for the Supreme Court. That's a different argument altogether.
Okay,
Your
so
lordship,
let me
we should
ask you
discuss it
this
on that
question.
ground.
Could I just get you to answer this question? When can a petition be filed under 32? According to you, no petition can be filed under 32. Everything should go under 226. So now you tell us,
Yes.
after everything that you've spoken so far, according to you, what are those situations where a petition under Article 32 can be filed? You have said it can never be filed if there's a remedy in the High Court. So tell us 10 examples of when a petition can be filed under Article 32.
Your lordship, the council would like to clarify that it is not telling that a petition cannot be filed under 32. It is suggesting that this petition can be moved to the relevant High Court, as issue 3 specifically deals with the mandation imposed by the state of Haryana, your lordship.
That's
And
right.
that's
But I want you to tell me what are those situations where a 32 petition will lie and a 226 will not.
Your lordship, the council requests a moment to generate the same. Does the council have the permission to do so?
Yeah, take your time. Yeah, it's your clock.
Indeed, your lordship. Your lordship, the same has been provided by the Supreme Court in the compilations which was cited, your lordship. And the council takes a moment to refer to the same.
I think my brother judge is asking a slightly more fundamental substantive question. Where do you file a 32 and where do you file a 226? Perhaps that's where you need to search for the answer and not a case law.
Your lordship, when a case can be dealt by the High Court, it is better if the petitioner goes to the High Court first rather than approaching the Supreme Court directly, as the Supreme Court can benefit from the decision of the High Court, your lordship. Thus, only when the High Court cannot deal with the case, it is better to approach the Supreme Court directly, your lordship.
So give me an example of when the High Court cannot deal with it and only the Supreme Court can deal with it. Give me an example.
Indeed, your lordship. Your lordship, in the very guidelines stated on 1st December 1988, the Supreme Court has laid down certain areas where it has stated categories which will ordinarily be entered as a public interest litigation by the Supreme Court itself. These include cases relating to bonded labor matters, the cases of neglected children, the non-payment of minimum wages to workers and exploitation of casual workers, petitions from jail complaining of harassment or premature release, petitions against police for refusing to register a case, harassment by police and death in police custody, petition against atrocities on women, in particular harassment of bride burning, rape, murder and kidnapping.
Council, instead of going through the catena of examples, does the pandemic actually go beyond one state or not?
Indeed, your lordship, it goes beyond one state, your lordship.
Then that's your answer.
Your lordship, with that, that is exactly what I'm contending in my second subcontention, that there are substantial questions of facts involved. Your lordship, in the case of Kailash Nath and another versus the state of Uttar Pradesh, It was held that only facts that have been admitted to be true and proven to be true can be considered by this court. Your Lordship, there are certain questions of facts which are left unanswered before this petition comes, Your Lordship. Firstly, there is no clue whatsoever regarding the range of side effects that can be there, the extent of damage that can be caused. And there has been only one district court case whatsoever where there is a claim for compensation against side effects. Your
Sorry,
Lordship.
let me just stop you there. You're saying that you don't know what the side effects are.
Your Lordship, the side effects right now there have been no cases where the side effects has been witnessed except for one district court case.
You didn't do any
After the
clinical
district
trials.
petition-
You have no information that anybody has had any side effects.
Your Lordship, the facts of the case are silent on whether any person has had any side effects during the clinical trials.
So you
or
can't
during
assume
medical
that there are
procedure.
none, right?
Indeed, Your Lordship, but there is no facts which are generated
No.
right now.
Therefore, you can't assume them. You're saying side effects are not known. That is not in the facts.
Your Lordship, but the side effects, but under Article 226, the High Court has the power to get into the questions of facts which need to be dealt.
There are no facts. We're not arguing facts. You're the one assuming facts. I'm asking you to show me from the fact sheet where it says there are no other side effects known.
Your Lordship, it is not clarified that there are no other side effects known.
Then
But
please
that
don't
itself
assume it.
is- That itself is unknown to the court, Your Lordship. It is
Counsel,
not
if I
known
can
to the-
ask you, if I can ask you the question differently, if there are no side effects, then why do you have a legislation granting immunity to the manufacturers?
Your Lordship, the legislation is prospective in nature. If there are any side effects which arise in the future, it is for that purpose, Your Lordship. There has been only one district court case where there has been a recorded case of side effects so far, Your Lordship. Your
What is the
Lordship,
process for finding side effects? Does the union government have a process for actually compiling what the side effects are?
Your Lordship, it is usually generated during the process of clinical trials, but the fact
That's
sheets
all
are
finished.
silent.
Now what do you do? Now do you have a way of finding out?
Your Lordship, when there are cases which come to the government, whether be it in hospitals or be it before the courts, that is the way the government gets to know about what the side effects are, Your Lordship.
So if a case is filed in the civil court, then you know that there have been side effects. Otherwise, you will not know.
Your Lordship, the facts of the case are silent on what are the mechanisms the government have to check such side effects, Your Lordship. But surely, when a person approaches the hospital for such a side effects, that can be recorded by the government, Your Lordship.
How?
Your Lordship, because he approaches a hospital and the hospital knows that the person has had a side effect because of the vaccination, and they can very well report to the government, Your Lordship.
But how do they report it?
Your Lordship, when it is a government hospital, there's a common database where it records the person, where it records the cases which have been there. And the government can very well collect the data from the government hospitals. And it can also request the data from private hospitals as well, Your Lordship.
But are you doing that or are you not doing that?
Your Lordship, the facts of the case are silent on that matter. The council can't comment on the same.
Do you have a duty to do that or not?
Indeed, Your Lordship. Very much.
So under which law do you have a duty to do that?
Your Lordship, when the government has the duty to protect the fundamental health of citizens. Thus, when the government is administering vaccinations to its public, it is a duty of the government to know what the side effects which are arising on any hospitals or any side effects which are being reported, Your Lordship. But right now, there is only one case of side effects which has been reported.
So it is your duty to know, but you don't know how you will know, and you don't know how you will find out.
Your Lordship, right now, this is an emergency and unprecedented situation, Your Lordship. Right now, there is only one case which we know, Your Lordship, which has been filed by the district court, Your Lordship. Otherwise, there are no. Right now, there is.
Correct. Sorry, the
Lordship,
question
can
is
you
not
please
about district
repeat?
court. Are you saying that no person has had a side effect in the last since March, right? So for the last 4 months, nobody has had a side effect because nobody has reported it to a hospital? Is that what you're saying?
Your Lordship, the fact sheets are silent on this issue, Your Lordship. The council cannot comment on the same on whether that persons have reported to the hospital or not regarding side effects.
No, you said you have information, right?
Your Lordship, I said that the government has a duty to collect such information, but the fact sheets are silent, and the council is not aware of that, Your Lordship, because the fact sheets are
And you
silent.
don't know under which law you have a duty.
Your Lordship, under Article 21, we have a primary duty to protect right to health, Your Lordship. And when the government is administering vaccines, it has the
Okay,
job to
go
know
on,
the
go on.
regarding
I don't think we're making progress. Go on. It's okay. Go to
Your
your next
Lordship, with
issue.
this, I would like to move to my second subcontention. With the second issue, Your Lordship. Your Lordship, it is submitted before the Honorable Court that the Epidemic Amendment Act 2021 is not in violation of Part 3 of the Constitution of Guyana. Your Lordship, this will be argued in two grounds. Firstly, that the amendment is not in violation of Article 21 of the Constitution, since it seeks to promote right to health. Secondly, it is submitted in arguendo that the provision of immunity to vaccine manufacturers is reasonable restriction and follows a due process of law. Firstly, Your Lordship, in the case of Consumer Education and Research Center and others versus the Union of India, it was held that with Article 21 read together with 38, 41 and 47, there is a duty upon the state to promote public health of the community at large. And in the case of Navtej Singh Johar versus the Union of India, it was held that the rights and interests of the community take priority over the rights and interests of the individual. Was there a question, Your Lordship?
What was the case of Navtej Singh Johar and how did it affect the rights of individuals and not, sorry, of the community and not individuals? Explain that to me.
Indeed, Your Lordship. Your Lordship, the case. Was there another question? Your Lordship, on April 27, 2016, 5 people filed a new writ petition in the Supreme Court challenging the constitutionality of Section 377 of the Indian Penal Code, Your Lordship. The petitioners claimed that the issues which they raised in their petition were varied and diverse from those raised in the pending curative petition in 2013 case.
That's
of
okay.
Kaushal
You don't have to
versus
read
Anastas.
to me what the story is. I asked you a specific question.
Indeed,
You
Your
read out a
Lordship.
paragraph which said that the rights of a group are larger than the rights of the individual.
Indeed, Your
Please
Lordship.
show me the paragraph in Navtej Singh Johar that says that and how it is relevant to the facts of Navtej Singh Johar.
Indeed, Your Lordship. In the case of Navtej Singh Johar, the petitioners alleged that Section 377 violates their fundamental right under Article 21. And Your Lordship, the opposition provided that the decriminalization procedures affected the right to religion under the right to religion, which considered Section 377 to be valid, Your Lordship.
Sorry, whose
And
argument was religion?
Your Lordship, the Utkal Christian Council, the Trust Growth Ministries,
Again, we're coming back to the same thing. So how did you come to the conclusion that it was group rights versus individual rights and group rights prevail? Show me the paragraph from Navtej Singh Johar which says group rights prevail over minority or individual rights. Can you show me that paragraph from Navtej Singh Johar?
Your Lordship, under Article 21, they claim that they have the right to self-identity. And Section 377 was violative of the same. Thus, it was the group right of all persons who wanted to determine self-identity, which was prioritized over the rights of certain religious councils, which were against this, Your Lordship. With this, I would like to move forward. Thus, Your Lordship, the right to public health takes precedence over the right to private health, Your Lordship.
So let's hold public health for a moment,
Indeed,
because I'd like to understand how is this not violative of Article 12?
Your Lordship, could you please repeat your question?
Yes. So Article 12 and Article 246, how is this not violative? Because you're stressing on public health.
Indeed, Your Lordship. Your Lordship, the council would like to answer that in the course of the argumentation.
So do you know which entry of Schedule 7? There's a short question. Which entry of Schedule 7?
Your Lordship, whereas in Schedule 7, the concept of public health is under state schedule, but
correct,
in the very case of the redistribution of essential supplies and services.
Don't go there. Don't go there. That is not a judgment of a court. That is just an order. Show me, Your Lordship, a judgment of any court anywhere in the world on legislative competence.
Your Lordship, the pandemic ensued in 2020, and this court has not been decided yet, but they have passed an interim order which states that it is the responsibility of the central government to procure vaccines and distribute it throughout the nation.
That's okay. You're not answering the question. Which entry of list 7 or Schedule 7? Show me entries in Schedule 7 which says you are competent to legislate. It's a simple question. It was not addressed in the suo motu matter by the Supreme Court. They did not deal with legislative competence. Can you answer the question quite simply? Open the Constitution, look at Schedule 7 and tell me the entry.
Your Lordship, while the Council admits that under Schedule 7, public health comes under the state subject, it is submitted before the Honorable Court in such an emergency situation where it is the central government which is procuring vaccines from the manufacturers as a whole. It is the responsibility of the government to promote public health, in this case, Your Lordship. Because
Under which provision of the Constitution? You keep saying it. Which provision of the Constitution?
Your Lordship, the Council is not aware of the same, as public health is under the state subject, Your Lordship.
Okay, move on.
I'll ask you another question, Council.
Indeed,
So,
Your
see,
Lordship.
what you obviously wanted to do was you wanted to support the vaccine manufacturers, right?
Indeed.
You needed to give them support given the emergent situation. Then, as an alternative formulation which doesn't impinge on the state list, why give them immunity at all? Give them compensation up to 30 lakhs a case separately. Why not that?
Your Lordship, I would like to state that the immunity granted is only to vaccine manufacturers, whereas the public or aggrieved person can move against the government in the same respective courts, Your Lordship. Thus, the government is rather taking responsibility for the process. And Your Lordship, it is also contended that it is the government which is discharging the duty of giving emergency approval to vaccines, of promoting the whole process of vaccination, and it is also the one which is administering vaccination, Your Lordship. Thus, the government is rather taking responsibility in this issue and also providing an additional remedy through Section 6, Your Lordship. With that, I
Council,
would like to...
Council,
Indeed, Your Lordship.
Council, may I ask, while we're on Section 5, is it limited to immunity against developers and manufacturers of COVID-19 vaccines, or does it apply to vaccination for other types of diseases as well?
Your Lordship, as it mentions, it is for the vaccine manufacturers which are notified by the central government, Your Lordship. And this legislation came during the COVID-19 vaccination and for the process of COVID-19 vaccination. So the vaccine manufacturers who are mentioned will be regarding the COVID-19 vaccine manufacturers. And only the manufacturers are granted immunity, Your Lordship. They can always approach the government.
Do we record an undertaking from the government that you won't use this for anything other than COVID-19?
Can't.
Your Lordship, the Council does not have the power to declare the same, but you might very well direct the government to answer this question, Your Lordship. Your Lordship, moving forward with this, and Your Lordship, this pandemic was unprecedented. We do not know regarding the second or the third wave or any other vaccines which might come or any other new disease or mutation which might develop, Your Lordship. And thus, it is valid that the government is placing the vaccine manufacturers which it deems fit, Your Lordship. With this, the Council would like to state that the whole process of vaccination is in the interest of public health, as vaccination for one person guarantees safety for another person. Thus, Your Lordship, it provides herd immunity to the public, and also the pandemic situation affects the other fundamental rights of the public as a whole, Your Lordship. Because of the pandemic situation, the government is forced to place restriction on free movements, religious events, the trade and profession, Your Lordship. Thus, when vaccination is provided, it promotes fundamental rights on multiple fronts, Your Lordship. Further, there are lack of hospital beds, Your Lordship. Thus, the country is facing an infrastructural scarcity, which increases the risk of a person affected by COVID. And there's a rapid increase of cases in the second wave, Your Lordship. And also, vaccines are inevitable. And thus, the policy promotes Article 21 and does not infringe it. Your Lordship, in the interest of justice, I would like to demand 2 more minutes from the Honorable Court. Or request 2 more minutes from the Honorable Court.
Ordinarily, we get requested, not demanded.
Indeed, Your Lordship. The Council stands corrected. The Council requests 2 more minutes from the Honorable Court. And Your Lordship, in the case of Maneka Gandhi versus the Union of India, it was held that fundamental rights are not absolute, but are subject to reasonable restriction. And this restriction placed, Your Lordship, is reasonable in nature. As firstly, the government is taking responsibility instead of the vaccine manufacturers, as it has already explained that it is the one which is administering the whole vaccination situation. And also there is a severe risk in stopping vaccine productions, Your Lordship, as the whole policy of the government to curtail this deadly virus depends on the whole vaccination process. And the second restatement of torts of the United States of America, which is also a common law country, deriving its legal system from the English common law system, states that vaccine manufacturers should not be held liable for unavoidable safety risks in vaccines, or when there was not adequate time to guarantee its safety. as long as the vaccine was properly prepared and accompanied by proper warnings. Your Lordship, I would like to state that the fastest vaccine which was developed before this was the mumps vaccine, which took 4 years to develop. This vaccine has been developed on a rapid basis around a period of 1 year. Thus, in record, this is the fastest vaccine to have been developed, Your Lordship. Thus, Your Lordship, it is contended before the Honorable Court that this emergency situation was in fact induced by the government, as it urged the vaccine manufacturers to come up with a vaccine quickly. And thus, Your Lordship, there is also an alternative remedy provided by the government under Section 6, Your Lordship. And the government is fulfilling its responsibility by both providing manufacturers fundamental rights and providing immunity to vaccine manufacturers, taking responsibility of all the side effects by itself, Your Lordship. And thus, the immunity is granted only to vaccine manufacturers and not against the fundamental right to health itself, Your Lordship. Thus, it is therefore submitted that the immunity granted is reasonable in the interest of general public, and it is fair, non-arbitrary, and follows the due process of law, and thus does not violate Part 3 of the Constitution.
Tell me,
But why
one
counsel?
question. Sorry, after you.
Oh, thank you. Why does the immunity take effect at once, but the compensation scheme under Section 6 does not take effect until the government prescribes a mechanism for it? How does that cut against your argument that the due process exists in the duality of the two?
Your Lordship, I would like to answer this in a two-phase manner. Firstly, a person who's aggrieved still has the power to go to any court against the government, whereas the alternative remedy has not come into force. It will do in the due course of time, Your Lordship. And when such an alternative remedy exists, it does not bar any person who was affected by the very virus before that also, Your Lordship. Thus, Your Lordship, there is an existing remedy right now. What the government is providing is an additional remedy, Your Lordship. Your Lordship had another question.
You're beyond time, that's fine, thanks.
Indeed, Your Lordship. Now my co-counsel will move forward to argue issue 3.
Greetings to the bench. May it please the court. As specified by my co-counsel, I will be taking 21 minutes of the court's time to argue issue 3, reserving 2 minutes for sir rebuttal. Your Honor, as the counsel for the state of Haryana, this counsel will be responding to the contentions made by the petitioner, wherein they challenge the regulation on the basis of its constitutionality and the ambit under the Epidemic Act. Your Honor, the counsel will be arguing this issue in a twofold manner, wherein the first part is about how the regulation upholds the values of the Constitution and is thereby not unconstitutional. Did Your Honor have a question? Much obliged. Your Honor, and the second part deals with how the regulation was implemented within the contours of the Epidemic Act and is thereby not ultra-virus to it. Your Honor, the counsel will first be arguing the second part of the issue, which states that the regulation is not ultra-virus to the Act. Your Honor, this regulation was passed under the ambit of the Epidemic Act, specifically under Sections 2, 3, and 4. Your Honor, Section 2, subsection 1 allows the state government to pass any legislation if there is a dangerous epidemic disease threatening the state. Your Honor, this very section is specific to the state government. Your Honor, the petitioner stated that the regulation is not temporary. However, this regulation was passed in light of preventing the spread of the virus. Moreover, Your Honors, there is no data to support when the pandemic shall end or the time by when the citizens can be completely vaccinated. As the bench rightly stated, this regulation was enforced until further notice, since there is no data about the end of the pandemic. Your Honor, the government cannot place a sunset clause in such a case, since an end date of the pandemic has not been found. The government fears... Indeed, Your Honor.
Almost all notifications under the Disaster Management Act, the Epidemic Diseases Act, all of them have come with sunset clauses. The rationale being it forces you to think as opposed to staying reactive. What
Indeed,
is
Your
the
Honor.
harm with a 1 month sunset clause?
Indeed, Your Honor. However, what the government fears is that by relaxing regulations post 1 month, or by giving citizens a false hope that the regulation will be removed after a month, the citizens might have a false hope, and thereby, Your Honor, this will go against the very objective of what the government seeks to achieve, which is preventing the spread of the virus. Moreover, Your Honor, Section 3 enables penalty for those who do not follow the regulations upheld by this Act under Section 188 of the IPC. Not in the exact words, but Section 188 of the IPC prescribes the penalty and punishment for those not following an order that has been promulgated by a public servant under this section. Moreover, Your Honors, Section 4 allows protection only to those public servants who have acted in good faith. The Regulation 2 states that only those acting in a judicious and humane manner to uphold the provisions of the regulation will be protected. Therefore, Your Honor, this regulation was very well passed only under the ambit of the Epidemic Act and is thereby not ultra-vires to it. If the bench is pleased with the council's arguments, the council shall move to the next part of the issue, wherein the petitioners contend that the regulation is unconstitutional. Your Honor.
We still haven't answered the question on virus. So if you can tell us which provision in the Constitution allows you to do this, then we can start there.
Your Honor, could you repeat the question? Could Your Honor repeat the question?
While we're looking at constitutionality, one of the challenges is ultravirus. Can you start from there and tell us which provision of the Constitution, which entry of which list of Schedule 7 allows you to have this legislation and allows you to have this amendment, allows you to have these regulations?
Indeed, Your Honor, the council shall argue Your Honor's question. Your Honor, under Schedule 7 of the Constitution, in the state list, Item 6 allows and empowers the state to take any regulation to uphold the health in the state.
No, it doesn't. Entry 6 allows you to legislate. Have you legislated?
Your Honor, the regulation has been passed under the Epidemic Act.
Under which provision of the Constitution was the Epidemic Diseases Act passed?
Your Honor, under entry 29 of the concurrent list, where also, Your Honor, the Epidemic Act was actually passed way before the enforcement of the Constitution.
Therefore, where do you find the competence for it?
Your Honor,
why should we not strike it down as unconstitutional?
Your Honor, under Article 13, it states that any law before the enforcement of the Constitution, if it upholds the rights and if it does not contain unconstitutional elements, it can be upheld and not deemed invalid.
Yeah, so we are now asking you the question: under which law can we hold? Under which provision of the Constitution can we hold this valid?
Your Honor, the council is not aware of said section.
Okay.
Indeed, Your Honor. The council shall now be arguing what the petitioner contends is that the regulation is unconstitutional. However, the respondents state that the regulation upholds the values of the Constitution, and the respondent shall argue this in a fourfold manner, in 4 limbs. The first limb, which states wherein the petitioner contends that the regulation violates Article 21. However, the respondent submits that this regulation upholds the ideals under right to health. The second limb, which states wherein the petitioner contends that the regulation violates Article 14. However, Your Honors, the respondent submits that the differentiation made is based on an intelligible differentia. The third limb, which states wherein the petitioner in their written submissions stated that the regulation violates the right to religion. However, Your Honor, the right to religion is subjective to public health. Moreover, the fourth limb, wherein the petitioner contends that Article 19 is violated. However, Your Honors, the respondent contends that Article 19 is subject to reasonable restrictions. Coming to the first limb about Article 21, Your Honors. Your Honors, In the case of K.S. Puttaswamy versus the Union of India, it was held that right to autonomy is an important facet of the right to privacy and can be denied if there's a countervailing public interest, thereby making it not absolute. Moreover, in the case of Mr. X versus Hospital Z, it was stated that the right to health of one prevails over the right to privacy of another. The state of Gobind versus the case of Gobind versus the state of Madhya Pradesh stated that the right to privacy can be denied if the countervailing interest of the public is superior and qualifies the state interest test. Moreover, provisions
Counsel,
Indeed,
Counsel,
Your
I'm curious, what about the right of health of people who cannot safely receive the vaccine, say those who have a history of severe allergic reactions to vaccines, those undergoing chemotherapy? Where in this law does it provide for an exception from the compulsory vaccination scheme for those people?
Indeed, Your Honor, the Council much appreciates this question. However, Your Honor, when the respondent enforces regulation, it only it took into interest the greater right of the public. Your Honor, the cases that Your Honor specified are very few in number and are not as much as the greater public. Moreover, Your Honor, this regulation was passed this regulation was passed to prevent overcrowding in the said commercial establishments and public transports, Your Honor. Thereby,
But is there authority of the state to waive the compulsory requirement in the case of such people who truly cannot receive the vaccine safely?
Your Honor, the Council is unaware of such a provision. If the bench pleases, the Council should continue with their arguments. Indeed, Your Honor. Your Honor, specifically, the paragraph 14 on page 5 of the Moot proposition states that the second wave was infectious and severe. Thereby, Your Honor, the government is duty-bound to protect the health of its citizens and thereby enforce the regulation under Article 47, a directive principle, wherein the state has the duty to protect the public health of its citizens. Your Honor, this was done in furtherance of Article 21, which guarantees the citizens of the right to health. Therefore, by urging its citizens to get vaccinated, the government protects the rights of all citizens at large. Your Honor, paragraph 4 of page 2 states that vaccine shall help combat the spread of the virus. Moreover, Your Honor, inferring from this opinion of the scientific community, the Chief Minister of Haryana, as specified on paragraph 15 on page 5, stated that vaccination will allow herd immunity, and this is the best method, in fact, of preventing the spread of the virus. Thereby, Your Honor, this states that from this, it can be reasonably concluded that vaccinating one person benefits the people around them. Thus, one person refusing vaccination would have repercussions for those around them. Your Honors, the petitioner stated the case of Aruna Shanbag versus the Union of India. However, Your Honor, the facts of this case is not the same as the facts of the current case. Your Honor, in the case of Aruna Shanbag, Ms. Shanbag had a disease, she was terminally ill, and she had a disease which did not spread. It was not a dangerous epidemic disease. However, Your Honor, in the instant case, there's a dangerous epidemic disease, which if not curtailed, can spread to the entire population. And Haryana, who already has a high number of infections and a high number of deaths, cannot take such a risk.
Okay, so let's understand the council. Why don't you simply make it mandatory to take vaccinations?
Your Honor, when the government mandates vaccines, it has to keep in mind certain objectives, wherein it cannot curtail the rights, the fundamental rights of every citizen, Your Honor. It can.
So then why make it inconvenient for somebody who chooses not to take the vaccine? What you can't do directly, why are you seeking to do indirectly?
Your Honor, this regulation was passed under the idea that by not allowing overcrowding at commercial establishments like offices and factories and public transport can prevent the spread of the virus. Your Honor, it has been stated that vaccination can combat the spread of the virus. Thereby, Your Honor, this regulation merely restricts the right of citizens only until they get vaccinated in order to prevent the spread of the virus. If that answers Your Honor's question, the Council would like to move forward with the arguments.
Just one last question, and I know you're running against time. Just on Article 14.
Indeed, Your Honor. Indeed, Your Honor.
Given you're not discouraging private transport, clearly people who can afford private transport can go from point A to point B. They can collect, they can congregate. But somebody who doesn't have private transport is bereft of the necessary means and who would only use public transport, then isn't it discriminatory to those people?
Indeed, Your Honor. However, it has to be noted that by private transport, there is no overcrowding, Your Honor. Private transport is of those people who and in a car, Your Honor, if people are traveling by a car, there are maybe 4 people who are from the same family and might not might not spread the virus to the larger public. However, Your Honor, public transport are used by a large part of the public, thereby increasing the chance of the spread of the virus. Hence, Your Honor, while this does not equally treat all citizens, this is the best alternative that the government has to prevent the spread of the virus, Your Honor.
Ms. Counsel, in the
Indeed, Your Honor.
context of the argument by the hello, can you
Indeed,
hear
Your
me?
Honor. Indeed, Your
Yeah,
Honor.
the context of the argument of the petitioners that you're obliged to follow the least restrictive alternative. Why haven't you tried to educate people that they should actually avail of vaccines rather than coercing them into it? We should actually have the opposite result than their objective. You've not followed the principle of the least restrictive alternative. What do you have to say about that?
Your Honor, while educating public is one alternative that the government has, Your Honor, in this case where the virus is spreading at a massive pace, Your Honor, it is important that the government vaccinates its citizens because this prevents the spread of the virus. Thereby, Your Honor, vaccinating the citizens is the least alternative remedy that the government has in this case. I hope that answers Your Honor's question.
Well, we'll see when we decide. You continue, please.
Indeed, Your Honor. Your Honor, in the case of Mr. X versus Hospital Z, it was decided that the right to health of one person prevails over the right to privacy of another. Your Honor, in this case, Mr. X contended that by telling his fiancée about his condition of AIDS, his right to privacy was violated. However, this court held that the right to health of the fiancé prevailed over the right to privacy of Mr. X. Moreover, Your Honor, in the case of Gobind versus the state of Madhya Pradesh, it was stated that when there's a countervailing public interest, and if the case qualifies the state interest test, privacy can be denied. Your Honor, in this case, when the virus is spreading at a large pace, at a massive pace, the government is duty bound to prevent the spread of the virus. Thereby, Your Honor, the government has mandated vaccines for those services wherein there can be a large overcrowding and which is accessed by a large part of the public. The council would like to move to the next limb of the argument, wherein the petitioner contends that the regulation violates Article 14. Your Honor, Article 14, in the case of the state of West Bengal versus Anwar Ali Sarkar, a nexus test for reasonable differentiation was propounded. The 2 prongs of this test was that 1, the differentiation between citizens must be based on an intelligible differentia. 2, that the differentia must have a rational object to be sought to be achieved by the legislation. Your Honor, in paragraph 14 on page 5, it states that second wave was more infectious than severe. Your Honor, thereby the government did its duty by ensuring that citizens be vaccinated as soon as possible. Moreover, Your Honor, item 6 of the state list allows the government to uphold public health of its citizens by creating legislations. Hence, Your Honor, the state is empowered to pass any legislation which seeks to achieve public health. Your Honor, according to the state, the test stated under the case of Anwar Ali Sarkar, this the differentiation that this legislation creates is reasonable because it differentiates between citizens who are vaccinated and citizens who are not vaccinated. Your Honor, it has
What
been
were the facts of Anwar Ali Sarkar? Did it have anything to do with public health?
no, Your Honor. However, the case propounded the two-pronged test, which stated that there should be an intelligible differentia for
No, but
reasonable
I want to
classification.
understand in what context did they do this?
Your Honor, the rights of factory workers were being violated in this case, and thereby the petitioner had approached the High Court of Calcutta, and the state of West Bengal had approached the Supreme Court in an appeal petition.
No, but about what? What were the factory workers seeking?
Your Honor, the
What was this
council.
discrimination? What was the classification in Anwar Ali Sarkar?
Your Honor, the council is unaware of the exact facts of the case.
Go on.
Indeed, Your Honor. Your Honor, the council would like to argue this from a more recent case. Your Honor, in the case of K.S. Puttaswamy, the four-pronged test for reasonable classification, the proportionality test, was propounded from the case of Modern Dental College. Your Honor, the petitioner contends that this regulation violates the third prong of this test. However, Your Honor, in a state where the virus is spreading at a massive pace, and the only alternative that the government has is to vaccinate its citizens and prevent the spread of the virus, there is no less restrictive alternative available in this case, Your Honor. Your Honor, in fact, the situation might reach a worse state if citizens are not vaccinated as soon as possible. And in a country like Guyana, which is highly populated, it is difficult to arrange for hospitalization for every citizen out there.
Can I ask counsel, why is it that none of the other states in such a large country have taken a similar measure? Why is it that only your state has this sort of an issue?
Indeed, Your Honor, the council appreciates this question. Your Honor, when the second wave of the pandemic had erupted in the Union of Guyana, the state of Haryana had recorded a very high number of infections and a very high number of deaths. Thereby, Your Honor, the government feared that this would cause a harm to the public health, and thereby enforced this regulation to uphold public health, Your Honor. Your Honor,
Counsel, is there any indication that there could be a shortage of the COVID-19 vaccine? And is there any concern that people would not be able to comply with this vaccine mandate because the vaccine isn't accessible to them?
Your Honor, as per clarification number 5, on page 2 of the clarification sheet, it has been stated that there is no shortage of vaccinations in Guyana, and thereby in the state of Haryana, and vaccination is available through all means required. Moreover, Your Honor, for those who might not be digitally literate, the vaccination process can be done online or offline through Seva Kendras. If that answers Your Honor's question.
Thank you.
Indeed, Your Honor. Your Honor, the council will now be moving to the third limb of the argument, wherein the petitioner states that the regulation violates the right to religion. Your Honor, the council seeks an extra minute to argue this contention. If, Your Honor, indeed, Your Honor.
Go ahead.
Indeed, Your Honor. Your Honor, in the written submissions of the petitioner, they have contended that the regulation violates the right to religion. However, Your Honor, Article 25, subsection 1 of the Constitution of Guyana, while it guarantees citizens the right to religion, the right to practice, profess, and propagate any religion, the same article also states that this is subject to public health, moral, and order. Your Honor, when there's a countervailing public health interest in this case, the right to religion is not a that the right to religion cannot be professed, Your Honor, and thereby they are not exempted from seeking vaccination. The council would thereby, Your Honor, the council for the respondents state that this regulation upholds the values of the Constitution and has been enacted under the contours of the Epidemic Act and is thereby constitutional and valid. Your Honor, the prayer is on the record. However, would you like the council to read it?
I just want to emphasize on one thing. if either you or your co-counsel want to answer that question on Schedule 7 as to where your Amendment Act or your notification comes in, you can do that. Otherwise, you can proceed. Okay,
Your-
don't stress. That's fine. No worries. I think good from my end. I don't know if any of the other judges have any questions.
Your Honor, would you like the counsel to read the prayer?
No, it's okay.
Oh, that's fine. It's a matter of record.
Okay,
Sorry.
thank you.
Before I begin my rebuttal, I would just like to confirm with the organizers that the petitioners have reserved 3 minutes for the same.
Yes, we have that on note.
Very well. My lords, there are several such points which the respondents have brought up, which are both flawed and are essentially a misrepresentation of the facts. The first and the most concerning point, my lord, is that the governments themselves have acknowledged that they have no idea about what the side effects are of a vaccine which they themselves are mandating. Furthermore, my lords, as the counsel for the respondents correctly stated, that these side effects are determined at clinical trial stage, and here the government claims that they have finished all clinical trials, that they have finished all regulatory processes, but they're still unaware of the side effects. So what is essentially happening, my lords, is that by mandating vaccination of the citizens, they're essentially treating their own citizens as guinea pigs, and they are waiting for somebody to report the side effects to a hospital, and only then will they take cognizance of it, and only if there's a substantial number will they take action on it. My lord, this can hardly be called a policy that is founded in reason. And furthermore, my lords, this is that same government that lacks basic hospital facilities, basic medical infrastructural facilities. The same government that is mandating vaccines despite not knowing the side effects, and the same government that is admitting that even the death of one individual can easily be subordinated to the benefits of the public, thus completely ignoring the right to life of an individual. And here we submit, my lords, that even if vaccinations are freely available in the state of Haryana, is it guaranteed by the government that a country which has such poor infrastructure and medical facilities, will they actually be able to carry out all the vaccination of all its citizens in just under a month, which is the time period that they have given? There is no assurance to the same. Furthermore, my lords, they have repeatedly relied on para 23 of their memorial, page 6, which speaks about the second restatement of torts, where they have stated that vaccine manufacturers should not be held liable for unavoidable safety risks. But they themselves have said in their own memorial that this is only when the vaccine was properly prepared and accompanied by proper warnings. My lords, that has been completely ignored in this case, as no information has even been given to the people. Furthermore, my lords, the scenario regarding the Epidemic Amendment Act is clear that there's a contractual obligation of all the vaccine manufacturers to provide vaccines by 26 November as per the Moot proposition. And therefore, the contention that these vaccine manufacturers will stop production is just an excuse, and the government has, in our submission, been pressurized by the vaccine lobby to take this step. Furthermore, my lords, it is our submission that instead of actually amending the Epidemic Act, even if they claim that it is imperative, they could have issued a regulation with a sunset clause of 26 November, which is anyway the date by which vaccine manufacturers have to produce their vaccines. Moreover, my lords, the government has repeatedly said that it is their obligation under Article 21 to ensure the right to health of the people, and the directive principles of state policy have been relied upon. I would like to answer this with 2 points. That first, as I've stated previously, a government which has no knowledge about the vaccines they themselves is administering is shooting in the blind and can hardly be said that they are preserving the right to health of the people, as they are as clueless as us as to whether the right to health will actually be maintained or not. And secondly, my lords, they have repeatedly stated that by mandating vaccination, say one individual refuses it, it will harm the lives around him. Now, my lords, the fact of the matter is this, that when one individual refuses vaccination, he can transmit it only to other individuals who have also refused vaccination. And thus, it is our submission that all these people who refuse vaccination know the risks and have taken it upon themselves. It is not like a man who refuses vaccination will transfer it to somebody else who wants to get vaccinated. They will have the immunity themselves as well. And therefore, my lords, we submit that overall, keeping all these points in mind, the facts have been misrepresented by the government. The law that they have relied hardly serves their purpose, as most of the measures taken by them can hardly be said to promote public health when they themselves don't know if it actually promotes public health or not. And furthermore, the clarification expressly state that no vaccine is 100% effective. So even if vaccines are given, it may not actually curb the pandemic, my lord, as there is no research on the same that has been released. And therefore, I would continue all this and conclude.
The council seeks a moment before approaching the court. That's fine, Your Lordship. Your Lordship, the council seeks permission to approach the bench with the reserved reports.
Yeah, get on with it.
Much obliged, Your Lordship. Your Lordship, the petitioners allege that there are no side effects known despite clinical trials conducted. And Your Lordship, and that the vaccine should be rolled out one day after we properly know all the side effects. Your Lordship, it's an emergency situation, and the vaccines have been rolled out for the past 4 months. And there have been one case registered in a district court, Your Lordship. We can't be waiting for the side effects to be completely known and then going forward to vaccinating our citizens, as there is already a second wave, and there is no surety on how many more waves there will be. And thus, Your Lordship, waiting for the side effects to be completely known would be a deadly decision, which will be taken by the government, Your Lordship. Your Lordship, and they also allege that the government lacks basic hospital facilities. And they told that thus, when they lack the hospital facilities, they should not be going forward with the vaccinations because they can't promote public health. Your Lordship, the fact that we lack hospital facilities right now is the prima facie reason that we're going to vaccination as our primary mode of fighting the virus, Your Lordship. And Your Lordship, hospitals can't be built over a night, whereas vaccinations are preventive in nature, whereas hospital beds are treatmental in nature. Thus, Your Lordship, prevention is always better than cure, Your Lordship. It is also submitted that building hospitals overnight is not a possibility, whereas vaccination is the need of the heart. Further, Your Lordship, they say that there is a contractual with the government, and when the manufacturers cannot stop production, the government can sue them if they do so. Your Lordship, does the petitioner believe that in an emergency situation like this, when people's lives are at risk, Your Lordship, do you have a question? Oh, Your Lordship, they believe that there's a contractual obligation for the vaccine manufacturers to provide the vaccines. And if they stop, the government can sue them under law. But do the petitioners believe that we have to risk the second largest population, the lives of the second largest population, based on a contractual dispute if the vaccine manufacturers stop production? If the vaccine manufacturers stop production, the effects will be highly detrimental, Your Lordship. Thus, the government is not providing them blanket immunity. It is rather taking responsibility in this course, Your Lordship. And thus, they also suggested that the public have to be educated before going for such vaccination. Your Lordship, and also, as already stated, the vaccines are rolled out on an emergency basis. Educating the public is a long-term plan which can't be done overnight, Your Lordship. Thus, vaccinations are mandatory and the government is promoting the same, Your Lordship. With this, the council would like to rest its case.
Thank you, everyone. Now, I would request the participants to leave the session, and they can join in the valedictory wherein the results will be announced. And the judges can meanwhile score and then proceed to the valedictory ceremony after a 10-minute break.
Thank you so much.
Sorry, are we going to another room now?
Once the participants leave, you can stay in this room only. It doesn't matter.
How do we know?
Yes, I'll notify you. Let's just leave. So all the participants have gone.
We will also leave. Khushi, I'm leaving. I'm the organizer. I'll leave.